Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Another eclectic week of cases, with 2 from the 5th, 2 from the 9th, and 1 from the 11th. In other immigration news, 5 of the 9 justices on the Supreme Court, constituting a majority, have decided to take up a state challenge to the enforcement priorities in the Mayorkas prosecutorial discretion memo, and to permit a lower court injunction of those priorities to remain in place through at least late 2022 when they hear the case. On the decision to leave the injunction in place, the 4 dissenting justices were the 4 female members of the court. I don't really think that indicates much, but it does seem noteworthy, if only to note that there are 4 female members of the Supreme Court. Also, it was the first record vote for Justice Ketanji Brown Jackson. And with that, here are your cases. Starting off with Ndudzi v. Garland, published by the 5th Circuit on July 20th, 2022. That's right, starting off with the 5th. This case is about asylum and credibility. Miss Ndudzi is from Angola. Well, technically, quote, Cabinda, an Angolan province that is geographically separate from the rest of Angola with distinctive dialect and culture, end quote. Apparently, it is a small and poor province adjacent to the Republic of Congo and the Democratic Republic of Congo. Quote, it produces half of Angola's oil, but has little local control of its resources and politics, end quote. Perhaps unsurprisingly then, it's been in a state of, quote, low-level separatist insurgency, end quote, since the 1960s. Most prominently, the main separatist movement is known as the Front for Liberation of the Enclave of Cabinda, or FLEC. And, quote, membership in FLEC is apparently often familial, end quote. While the FLEC has dwindled significantly since the 2006 peace agreement, it still has carried out violent attacks, quote, including shooting at the Tongolese national soccer team as it drove through Cabinda to the African Cup in 2019, end quote. So naturally, the Angolan government and military remains interested and active against the FLEC. Enter Miss Ndudzi. She claimed that the Angolan government identified her as a, quote, supporter of the independence movement after she attended a church-organized pro-independence rally in 2016. Soon thereafter, 3 armed men in government uniforms broke into her home and, in front of her children, beat and raped her, leading to a 3-day hospital stay, end quote. That's almost surely an asylum win if believed, but the IJ did not believe it. Namely, the IJ found Ms. Ndudzi not credible because while she testified in court that she was not part of the FLEC, quote, the IJ interpreted unsworn, non-verbatim statements from Ms. Ndudzi's credible fear interview, or CFI, as indicating that Ms. Ndudzi was a member of FLEC, end quote. All the worse because the IJ then decided that FLEC is a terrorist organization. The BIA affirmed the adverse credibility stuff, but the Fifth Circuit reversed. Now first, Ms. Ndudzi argued that the credible fear interview notes, which are not verbatim translations of what was said to the asylum officer by any means, are inadmissible. And the Fifth Circuit seemed a bit sympathetic, but avoided that consequential ruling, holding that even if properly admitted in immigration court, they don't support an adverse credibility finding here. Remember, in the Fifth Circuit, like everywhere, a credibility determination must consider the, quote, totality of the circumstances, end quote. In the Fifth Circuit, a single omission or inconsistency can tank a case, but only if it establishes non-credibility in totality. Remember that. Most important to the IJ here, the asylum officer's credible fear notes indicated that Ms. Ndudzi had said, and again, not a transcript, that she was, quote, part of the group that fights for independence of Cabinda, end quote. The IJ interpreted that to mean FLEC, thereby contradicting, in the IJ's mind, Ms. Ndudzi's claims at the individual hearing that she wasn't part of FLEC. But the Fifth Circuit didn't see an inconsistency read in the full context of the non-verbatim credible fear interview notes. Ms. Ndudzi was never directly asked if she was part of FLEC, and she never said that she was. To the Fifth Circuit, quote, there is no express inconsistency, end quote. Even worse, to the Fifth Circuit, quote, when faced with seeming inconsistencies between the credible fear interview notes and Ms. Ndudzi's sworn testimony, the IJ and the BIA not only declined to credit Ms. Ndudzi's sworn testimony, they accepted as true the notes' unsworn, non-verbatim statements while ignoring evidence to the contrary, end quote. For example, Ms. Ndudzi offered her testimony and an expert opinion, noting the, quote, common Cabindan saying, we are all FLEC, end quote. So maybe that explains some of her statements during her asylum interview. The only time she ever spoke under oath, before the immigration judge, she swore she wasn't FLEC, and her partner similarly swore under oath that she wasn't FLEC. In a quote that I love, the IJ and the BIA erred when they, quote, decided to weigh Ms. Ndudzi's inferred statement from a non-verbatim report to which she had not specifically attested over the more formal record evidence and sworn testimony to the contrary, end quote. Great quote for attacking credible fear interview notes. The Fifth Circuit went on to explain that some of the other identified inconsistencies weren't that inconsistent, and they were tangential at best to Ms. Ndudzi's case. All the more important here in totality were the record also had sworn statements from witnesses to that past persecution in Angola. In fact, quote, the BIA's opinion did not cite any of this corroborative evidence, end quote. That's error. Additionally, the IJ also based the adverse credibility finding on Ms. Ndudzi's demeanor during the individual hearing, which the IJ described as, quote, agitated, end quote. But whatever the merits of that finding, the Fifth Circuit has, quote, never held that demeanor alone supports an adverse credibility finding where the agency failed to consider an asylee's corroborating evidence, end quote. Well. Concluding with Convention Against Torture Protection, as the BIA knows, a CAT claim doesn't necessarily fail even if an IJ finds the non-citizen adversely credible. Apparently then, quote, the BIA mischaracterized the IJ's decision, end quote, to make it seem like the IJ had denied CAT based on Ms. Ndudzi's failure to meet her evidentiary burden rather than because of the adverse credibility finding. But the BIA can't do that. The IJ, quote, did in fact rely heavily on the adverse credibility determination, end quote, to deny CAT, and the BIA isn't allowed to hold otherwise if it's going to affirm the IJ. The BIA cannot rewrite the record. So it all goes back, in what must have been one heck of a fight by Ms. Ndudzi's attorney or attorneys. Congratulations, everyone. And oh, by the way, Ms. Ndudzi was kidnapped in Mexico during her smuggling experience into the U.S. But now she's going to get another shot at relief with a very strong appellate decision behind her. And how about this? In a footnote, the Fifth Circuit questions whether courts should be deferring to adverse credibility findings at all when those findings are based in demeanor. Citing a variety of scholarly publications, the Fifth Circuit states that, quote, deference is perhaps unfounded, given the wealth of contemporary psychological research suggesting that subjective perception of a witness's demeanor is an unreliable indicator of the witness's veracity, end quote. Something necessary to include in your adverse credibility demeanor appeals. And that is Ndudzi v. Garland. Next up is Masin-Ventura v. Garland, published by the Fifth Circuit on July 21st, 2022. Sticking with the Fifth, we have a very short one about equitable tolling. And to be honest, the court doesn't provide that many details. What we do know is that in 2006, Ms. Masin-Ventura was ordered removed in absentia because she didn't appear for her court hearing. In 2019, she filed a motion to reopen through counsel. Ms. Masin-Ventura didn't argue that she didn't receive notice of her hearing. That wouldn't have any time deadline. But instead, she argued that she missed her hearing due to exceptional circumstances. The problem is that motions that make such an argument must be filed within 180 days of the hearing. This motion was filed 13 years later. Now, luckily for Ms. Masin-Ventura, that 180 days can be equitably tolled. But in the Fifth Circuit, like everywhere, I believe, the non-citizen must show that exceptional circumstances stood in the way of timely filing, and that the non-citizen acted diligently in eventually filing the motion. Only then can a motion to reopen filing deadline possibly be extended. So Ms. Masin-Ventura is going to need to show that for 13 years. And actually, here it appears that everyone agrees that Ms. Masin-Ventura showed that there were exceptional circumstances present. At least that was the posture before the Fifth Circuit. And so before the court, it came down to due diligence. Ms. Masin-Ventura argued that, quote, she acted with reasonable diligence given the extraordinary circumstances of her case. Specifically, she claims that she was forced into an abusive marriage where her free will was dominated by her assailant, and that her assailant prevented her from obtaining information about her immigration status and the 2006 removal proceedings, end quote. But to the IJ and the BIA, Ms. Masin-Ventura could not establish diligence because in her motion and presumably in the accompanying affidavit that she included, she, quote, did not state when the abusive relationship ended, nor did she identify when she learned of the in absentia removal order or what steps she took following that discovery, end quote. And the Fifth Circuit agreed with the IJ and the BIA because, at a minimum, Ms. Masin-Ventura had an attorney for 2 years before she filed her motion to reopen. To the Fifth Circuit, that undermined any diligence showing for at least 2 years. In fact, the Fifth Circuit then goes on to essentially set the stage for an ineffective assistance of counsel type claim against Ms. Masin-Ventura's motion to reopen attorney if that 2-year delay in filing was the attorney's fault. What a mess. And Ms. Masin-Ventura lost her case. And that is Masin-Ventura v. Garland. Next up, Bravo v. Garland, published by the Ninth Circuit on July 18th, 2022. This case is about reinstatement and jurisdiction. Always a podcast favorite. Read the decision on all of what I'm about to say and check me on deadlines. This is not, of course, legal advice. Reinstatement. Under INA Section 241A5, if a non-citizen has re-entered the United States illegally after having been removed, quote, the prior order of removal is reinstated from its original date and is not subject to being reopened or reviewed, end quote. Where properly done, the non-citizen is simply physically removed again, based on a prior order of removal that DHS has reinstated. And reinstatement by DHS is really hard to challenge, although there are some circuit-to-circuit exceptions. For example, in the Ninth Circuit, the Ninth may review a non-citizen's claims that, quote, the agency failed to comply with applicable reinstatement regulations in conducting the reinstatement proceeding, end quote. The Ninth Circuit may also review a, quote, collateral attack on the underlying removal order if the non-citizen can show that he has suffered a gross miscarriage of justice in the initial removal proceedings, end quote. Such a challenge would travel under a direct petition for review to the Ninth Circuit, filed 30 days, quote, from the date of the final reinstatement order, end quote. Separate from that, DHS's decision to reinstate a final order, and it is just that, a discretionary decision by DHS, generally precludes a non-citizen from moving to reopen their prior removal proceedings. So therein lies the question before the court here. What happens if DHS reinstates, and then a non-citizen files a motion to reopen his or her removal proceedings, arguing that absent reopening, a gross miscarriage of justice will occur? Kind of trying to get that straight petition for review reinstatement challenge standard to travel under a motion to reopen vehicle. Well, the Ninth Circuit said that courts can't review such an argument. The vehicle is improper. And that's what Mr. Bravo was trying to do here. He was a lawful permanent resident and was ordered removed, and he was physically removed to Mexico following some Washington state drug convictions. He re-entered unlawfully, and DHS did indeed reinstate his final order of removal. Mr. Bravo simultaneously challenged that reinstatement with the Ninth Circuit on direct petition for review, and then also moved to reopen in immigration court. A smart move, but both ultimately unsuccessful. And only that motion to reopen challenge is at issue here. It didn't matter to the Ninth Circuit that Mr. Bravo may no longer be removable as a matter of law for his Washington convictions, or that those Washington convictions may have actually been expunged because the conviction violated Mr. Bravo's Sixth Amendment constitutional right to counsel. Simply put, no court, according to the Ninth Circuit, has jurisdiction to hear the motion to reopen after DHS reinstated the final order of removal. Again, the Ninth Circuit has jurisdiction to review the straight challenge to the reinstatement order itself, which it denied separately, but not to a motion to reopen after reinstatement. Reinstatement destroys the ability to move to reopen in the Ninth Circuit, no matter the gross miscarriage of justice that may result from reinstating that unopened final order of removal. Heck, IJs don't even have authority to do so sua sponte, according to the Ninth Circuit. Even if the regulations grant such unfettered sua sponte authority to immigration judges, the regulations can't trump the statute, and to the Ninth Circuit here, as well as in its Cuenca decision 2 years ago apparently, the statute is clear. No reopening after reinstatement. Rough. Mr. Bravo therefore did not succeed. Where do we go from here? Well, for what it's worth, the Ninth Circuit and the BIA seemingly do have, quote, jurisdiction to review the denial of a motion to reopen a reinstated removal order for legal or constitutional error, end quote. The Ninth Circuit panel is holding that is a very limited exception here. I can't quite think of situations that might be applicable after this decision, but maybe the last remaining line of attack in the Ninth Circuit is to argue that a framework implemented by Congress that permits non-citizens to have their statutory right to a motion to reopen taken away simply because DHS decides to reinstate a final order of removal as a matter of discretion violates a non-citizen's constitutional right to due process, at least as applied, where doing so will result in a gross miscarriage of justice. Maybe, like, say, where the removal order was plainly wrong at the onset? Pick the right case, and naturally a difficult argument. And of course, make sure that the Ninth Circuit's Cuenca decision doesn't actually take that away, too. But if it doesn't, there the argument remains. And that is Bravo v. Garland. Next is Lopez Luvian v. Garland, published by the Ninth Circuit on July 19th, 2022. Back-to-back days with decisions from the Ninth Circuit stripping it of jurisdiction to review issues related to reinstated removal orders, albeit in quite the unique procedural posture. Mr. Lopez is from Mexico and was ordered excluded from the U.S. in 1996. He was physically excluded from the U.S., or maybe he wasn't even let in to begin with, I don't know. It's a bit unclear. The framework for removal and exclusion and deportation was a bit confusing in 1996. And I, of course, as an elder millennial, was relatively young. Mr. Lopez entered the U.S. unlawfully in 1999 and remained in the U.S. for a long time. In 2007, he applied to adjust to LPR status before USCIS, likely through his marriage to a U.S. citizen. But USCIS denied, based on a finding that before, in 1996, he had made a false claim to U.S. citizenship at the border. DHS then initiated removal proceedings. It did not reinstate that prior exclusion order, but rather it reserved Mr. Lopez with a notice to appear. That provides Mr. Lopez with the full panoply of rights and potential forms of relief that removal proceedings have to offer. Mr. Lopez did not reapply to adjust status in immigration court because, I'm not sure, but maybe it's because it appears he re-entered unlawfully and so doesn't have a lawful admission, but instead applied for non-LPR cancellation of removal under 240AB because he must have had a qualifying United States citizen or LPR relative who would suffer hardship if he were removed to Mexico. But then, DHS realized that it didn't have to give Mr. Lopez all of those rights in removal proceedings, and twice moved the IJ to terminate proceedings so that instead it could simply reinstate that 1996 order of exclusion. The IJ denied the motions, found that Mr. Lopez had established the required extreme and exceptionally unusual hardship to a qualifying relative, and granted him non-LPR cancellation of removal and put him on a path to LPR status. Not easy to get. But DHS decided to appeal as part of its litigation strategy, and simultaneously moved the BIA to simply dismiss the case entirely. And the BIA obliged DHS, notwithstanding the hardship finding made by the IJ. The BIA just dismissed it all so that DHS could reinstate the 1996 exclusion order. So remember, practitioners, the BIA can just dismiss proceedings while an appeal is pending if you move them to do so. 2 years later, DHS decided to indeed reinstate that final order of exclusion. Mr. Lopez petitioned for review to the Ninth Circuit that exclusion order, as is his right, quote, but the petition does not challenge the reinstatement decision itself. Instead, it purports to challenge the BIA's much earlier 2014 decision terminating his removal proceedings, end quote. And that, said the Ninth Circuit, Mr. Lopez could not do. Now true, said the Ninth. INA Section 248(2)D permits it to, quote, review a petitioner's claim that he has suffered a gross miscarriage of justice in the initial deportation proceeding, end quote. But Mr. Lopez didn't make that argument here. That would have been a challenge to the 1996 exclusion order. He was really challenging that 2014 BIA termination decision. To the Ninth Circuit, it didn't matter one way or the other whether the 2014 BIA decision terminating removal proceedings anew was a gross miscarriage of justice, because it's the proceedings to be reinstated that remain the Ninth Circuit's focus. True, DHS is not required to reinstate a final order of removal and can instead serve a notice to appear upon a non-citizen. But if it chooses to reinstate as a matter of its discretion, all of these very adverse consequences follow. The Ninth Circuit rejected the argument that the, quote, termination of removal proceedings was reviewable because a reinstated removal order was foreordained, end quote. Reinstatement is not automatic. DHS doesn't have to do it. So Mr. Lopez could not challenge the termination of the 2014 removal proceedings, even if it was designed to lead to reinstatement of that 1996 exclusion order. Apparently all of this aligns with a 10th Circuit decision from 2012 and other 9th Circuit precedent. And accordingly, the 9th Circuit dismissed the petition for review. But I must note, I'm not sure that USCIS was quite right to deny adjustment of status on the false claim to U.S. citizenship grounds in 2007. As I understand it, the false claim to U.S. citizenship and admissibility provision didn't come into effect until IRIRA, and here, Mr. Lopez made that false claim pre-IRIRA in 1996. I'm nearly positive that false claims to U.S. citizenship don't make someone inadmissible retroactively. So, I'm nearly positive that USCIS was wrong to deny adjustment of status on this basis in this case. So there's that, in addition to everything else. And that is Lopez Luvian v. Garland. Finally, we have Dacostagomez-Aguilar v. U.S. Attorney General, published by the 11th Circuit on July 19, 2022. This case is about in absentia motions to reopen and deficient NTAs. What would I do on the podcast without these issues? Quote, in October 2003, 17-year-old Samuel Dacostagomez, along with his mother, little sister, and 2 young cousins, crawled under a border fence that separated Mexico from Arizona. End quote. He and his family were picked up by CBP very shortly thereafter and served with notices to appear. The NTA listed that the first hearing would be in the Phoenix Immigration Court, but did not have a date or time of that first hearing included in the NTA, in violation of INA Section 239A. Mr. Dacostagomez's mother gave CBP an address in Georgia, and apparently, 2 months later, the Phoenix Immigration Court sent a hearing notice to that address. But a few months after that, the family moved again to the grandmother's home in Dalton, Georgia, and did not update the court. They moved again, and didn't update the court again. Separate from all of that, it seems, Mr. Dacostagomez's aunt also had a removal hearing, or at least her children did. And the aunt moved to transfer her family's case to the Atlanta Immigration Court. For reasons unexplained, the Phoenix Immigration Court added Mr. Dacostagomez's case to his aunt's case, which seems to be totally improper, and then transferred it and the aunt's family's case to Atlanta. The notice of that new hearing in Atlanta was sent to the first address for Mr. Dacostagomez in Georgia, and it was returned to the Atlanta court as undeliverable because he didn't live there anymore. And so, when he didn't appear, Mr. Dacostagomez was eventually ordered removed in absentia in 2005. As an adult many years later, Mr. Dacostagomez moved to reopen those proceedings in 2019, arguing that he did not receive proper notice of his hearing as the INA requires, thereby requiring reopening of his in absentia removal order based on the Supreme Court's decision in Pereira v. Sessions. The 11th Circuit appears to be a bit dismissive of the argument, framing it as such. Quote, he argued that under Pereira, he could not be removed because the notice to appear he received when apprehended on the highway had not included the date and time of his initial hearing. End quote. But it's an argument that should win in the 9th Circuit based on the Singh decision, and it's an argument that might win in the 5th Circuit based on the 5th Circuit's Rodriguez decision. Indeed, had proceedings not been improperly transferred to Atlanta and remained in Phoenix in the 9th Circuit, the result for Mr. Dacostagomez might be very different. But he was, and is, in the 11th Circuit. And the 11th Circuit has now rejected the argument that the in absentia removal order must be reopened, notwithstanding the deficient NTA, thereby creating a circuit split. Seemingly a bit conflicting with the Supreme Court's Chavez decision, the 11th Circuit held that, quote, in absentia removal is lawful so long as the government provided notice for whichever hearing was missed, end quote. Unlike the 9th Circuit, and to an extent the 5th, the 11th Circuit believed the statutory text of the INA supports this result. The statutory text of the in absentia removal order reopening statute permits reopening where the non-citizen shows that he, quote, did not receive notice in accordance with paragraph 1 or 2 of Section 239A, end quote. Section 1 refers to NTAs, and Section 2 refers to notices of hearing. So the 11th Circuit held that proper service of either of them bars an in absentia motion to reopen based on a deficient NTA. To the 11th Circuit, quote, the use of the disjunctive or indicates alternatives and requires that those alternatives be treated separately, end quote. I don't know though, and sorry for the in-case commentary, but without it would get a bit confusing. It seems to me that the text requires the opposite conclusion. As the 9th Circuit and the 5th Circuit have kind of held, a motion to reopen is proper where either the NTA or the notice of hearing is deficient. The use of the word or would appear to benefit a non-citizen's motion to reopen ability with this statutory text, rather than undermine it. But the 11th Circuit held otherwise. And I don't know if even the 11th Circuit panel is completely swayed by the text, because to support its conclusion, it held that, quote, the full context of the statute announces its meaning, loud and clear, end quote. After all, said the 11th Circuit, to obtain an in absentia removal order in the first place, under the in absentia statute, rather than the reopening statute, DHS must only prove that the notice of hearing was properly mailed. Instead of reading this as a contradiction within the INA, the 11th Circuit read it as supporting its reading of the in absentia reopening statute. To hold otherwise to the 11th Circuit would, quote, defy common sense, end quote. In essence, the 11th Circuit adopts the two-step process for providing hearing notices rejected in Chavez in the cancellation of removal context, and held that a notice of hearing will undermine fatally an in absentia motion to reopen that relies on a deficient NTA argument. The holding here also aligns with the BIA's similar recent decision in matter of Peña Mejia. As to Mr. Dacostagomez, well, he did not show that he properly updated the Phoenix Immigration Court at the age of 17, and so, in the 11th Circuit and pretty much everywhere, he is not due notice of his hearing because of this failure. This means that he cannot reopen his in absentia removal order from all of those years ago. The 11th Circuit also found no due process violation in the fact that the, quote, immigration judge in Phoenix changed the venue on his aunt's motion, end quote. Now true, under 8 CFR section 1003.20b, an IJ can change venue, quote, only upon motion by one of the parties, end quote. The aunt wasn't a party to Mr. Dacostagomez's proceedings, so it definitely seems that what the court did in Phoenix violated the regulations which the court in Phoenix is bound to comply with. Maybe so, but to the 11th Circuit panel, quote, a mere irregularity in agency procedure does not deny a person due process, end quote. And because the immigration court did try to inform him about the changed venue hearing, so the court reasoned, quote, his due process argument fails, end quote. Mr. Dacostagomez therefore did not succeed. And we have the circuit split needed to now have the Supreme Court issue a third decision on deficient NTAs. Let's see if the court takes the invitation. Here's looking at you, Justice Gorsuch. And that is Dacostagomez-Aguilar, the U.S. Attorney General. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.